Hello and welcome back to the another episode of Indian Polity Lectures. Well, it is lecture number 8 today, and in this video we are going to continue the chapter about fundamental rights, and today we are going to discuss Article 19. You know, before we will start our discussion, as usual, I would like to give the brief introduction about this initiative so that if you are new to our channel, you will get more connected with us. And if you want to join our initiative, you would subscribe us. You know, about this initiative, we started it from 2nd June. And in this initiative, every day we are going to upload two videos, one with respect to current affairs, which is in the morning or afternoon session, and the second with respect to the static syllabus, which is in evening or night session. In the morning session, we discuss the important news articles which are relevant for your preparation. We break them down and we try to take up everything which is relevant for you, whether related to prelims or mains. And in the static part, as we had promised you that by the month of Jan 2026, we will try to complete your full syllabus. In it we are going to conduct the lectures of every class, every subject which is relevant for your preparation. And we started with Indian polity. Only thing which we are not going to conduct here is related to optional subjects. That is for the mains. We are not going to conduct the lectures for them. Otherwise, the rest we are going to conduct here. We are going to deliver here. So if you are interested in in letting us be the part of your journey, so please do subscribe the channel and share it with your friends so that they may also get benefited from this initiative. Now, one more thing I would like to add here, as we are giving you the lectures which are totally free, we are trying to discuss everything which is relevant for your preparation. At the same time, we are making notes of these subjects. Currently, as you know, we are discussing Indian polity and we are making notes of Indian polity, and they would be available after we will complete the whole discussion, or I would say after we will complete the syllabus of Indian polity. Indian notes for Indian polity would be available. But if you want to get that, if you want to read those notes, you would have to pay only 200 rupees for that, for each subject. One thing I will guarantee you, that these notes will contain every factual information which would be relevant for your prelims preparation. We will try to contain everything, as well as the conceptual understanding of the subject. So it would be the one stop book for you about this subject. If you would be interested, you can buy it, you can mail us, and we will definitely send this book to you guys. So this is about the initiative, this is about the advertisement. If you want us to be the part of your journey, please do subscribe the channel, do hit the notification button so that you will get to know when we are uploading the video, and do share it with your friends so that they may also get benefited from this initiative. Now let us start our discussion by looking at Article 19. Before we will start discussing Article 19, let me give you the little recap what we discussed so far. We started with the constitution. We discussed its types, we discussed its important features. Then we discussed part 1, in which we discussed union and its territories. We discussed them in a very detailed manner. After that, we discussed part 2, in which we discussed citizenship. And then we started with part 3, which is fundamental rights. And in fundamental rights, we first discussed Article 12, how it defines state. Then Article 13, what is the status of the laws which were pre-constitution, if they are violative of the fundamental rights. We discussed that. How can Parliament amend the fundamental right? We discussed all that stuff related to it. Then we discussed Article 14, related to freedom of equality before law and equal protection of the law. We discussed Article 15. We discussed Article 16 yesterday in a very detailed manner. We discussed the concept of reservation, how Article 16 gives the scope for the reservation. We discussed how reservation in itself is not a fundamental right. If the government is not giving you the reservation, then you can't go to the court and we highlighted the example of the Uttarakhand government when they notified the posts for certain jobs in which SCs and STs could not use their caste status, this status to get the reservation during promotion. And the case went to the Uttarakhand High Court, and Uttarakhand High Court asked for the data. Then they went to the Supreme Court. Supreme Court said that Uttarakhand High Court is not doing great here. You are not supposed to give the data. It is up to you. If you want to give the reservation, that is fine. If you don't want to give the reservation, that is also great. Nobody can force you, because reservation in itself is not a fundamental right. Then we discussed various things. We discussed reservation earlier, how it was limited to SCs and STs, then how the scope increased to OBCs, other backward classes. Then we discussed various commissions too. After that, we discussed how it reached till the economically weaker sections also. 10%, how first Narasimha Rao, his government tried to introduce it, but it was by the Indra Sahni judgment, it was made unconstitutional. Then how the amendment was made, Constitutional Amendment 103. Through this amendment, it was made very much constitutional and was introduced as Article 16(6). So this is the whole history till now what we discussed. So today, and then after we discussed Article 17(2), the untouchability, related to untouchability, how it is prohibited. It is not just the literal meaning of untouchability. If we will give the literal meaning of untouchability, then during COVID-19, everybody would have been in jail. Everybody would have been in the Atrocities Act. But it has a wider meaning. There is a wider picture. It is basically talking about the atrocities faced by those people during the pre-independence era, during the history, how this concept of untouchability was prevailing in our society, and it was to end that concept. This is the actual meaning. And with respect to that, we saw that how different laws were formed. Atrocities Act, how it is the burden of proof is on the accused, not on the prosecutor. How there were allegations that it is being misused by the SCs and STs. Then how court a little bit interfered with the Atrocities Act, but there were many protests against that, and finally Parliament restored the earlier picture. We discussed that. After that, we discussed Article 18 also, how abolition of titles, how it came in, how they were abolished and accept the military and educational titles. We discussed the status of Bharat Ratna and all the awards given by our government, but they can't be used as a prefix. There was a case whether it violates Article 18 or not. Then the court said we have to highlight the merit. We have to acknowledge the merit. After that, we discussed various sub clauses of Article 18, that if a foreign dignitary, he is working in the office of the prophet and his country is giving him any title, then he has to take the permission of the president. If any foreign country is willing to give you the title, you can't accept that. We discussed the case. I don't remember whether we discussed the case with Sunil Gavaskar or not. Well, that is the same case. The English government, they wanted to give him the knighthood because he was the first to score 10,000 runs from India, in tests. So English government wanted to give him the title of knighthood, but he was supposed to not accept that because it would violate Article 18 subclause 2. Similarly, if a Indian national, he is working in the office of the government and he is supposed to be given the award from the foreign country, then he has to take the permission of the government. So this is what, in nutshell, what we discussed till now. Now let's start with the Article 15. Article 19, but before, let me rub it. Article, till now we were discussing the right to equality, which were included in the Constitution under Article 14, 15, 16, 17 and 18. Now from today we are going to discuss the right to freedom. And right to freedom, it is very beautiful article. Right to freedom, without this you cannot breathe. Without this article, without Article 19, if it is not there, you cannot even breathe. You cannot even live your life with the dignity what you deserve. You cannot live with your life. This article, this Article 19, it gives you the life. It gives you the air to breathe in. It gives you the space to express. So let's see what does the Article 19 say. First, let's have a look at its context. Then we will start discussing it. it may take a while because it is a big article. We have to discuss the article clause by clause, and at the same time we have to discuss its restrictions. So let's see what does the article say. Here you can see the article 19. It is talking about the protection of certain rights regarding the freedom of speech and others. So what are these rights? Here the article 19 clause 1 says all the citizens shall have the right. First, clause A, freedom of speech and expression. What is this freedom of speech and expression? Is it confined to the literal meaning of it? Is it a freedom of speech and expression? Is it confined to the literal meaning of this, that there is freedom of speech and expression? There is, it is a very broader term. If you will look at this term itself, it is a very broader term. It has a wide meaning in it. For example, let's take an example of an political parties. Here we have the ruling political party, which is BJP. Suppose the opposition is right now, let's suppose it is Congress, and Congress, if they don't have this right to freedom of speech, suppose they want to criticize the BJP government, when they will criticize them, in this way they are educating the people about the political nature of the country. They have to criticize the government, they have to educate the people about the political nature of the country, they have to educate the people about the politics of the country, what is prevailing right now. They have to, this freedom should be there. If this freedom is not there, then what will be the situation of the country? If this freedom, if you cannot criticize the government, if you cannot criticize the policies of the government, then what would be the future of the country? Then there, it would have a very different, then the democracy, it won't be even called the democracy, as it is said, if the freedom of speech, it is said that the freedom of speech, it lies at the foundation of the democratic organization. If there is any country and there is the freedom of speech, then we can say the country has this norm of freedom of, then the country is fully democratic. So this freedom of speech, it is not inferred. If we look at it, it does not say that you can criticize the government, but it is inferred from it. So this freedom of speech in itself, it has a very huge meaning. And who interprets it? It is the judiciary. It is the judiciary who will interpret it. So let's cite some examples by which we can say that judiciary indeed has interpreted it in many ways. First, we will take the example of the national flag. Let's take the example of the national flag, and let's dig a little deep into the history of it, and then you will understand how the judiciary has impacted, how the judiciary interprets the underlying the freedoms under this statement, under this broader statement, that freedom of speech and expression. Let's try to understand that. Well, there was a guy named Naveen Jindal. Naveen Jindal. He went to Supreme Court. For what reason he went to Supreme Court? Because there was a flag code law in our country. There was a flag code. And what is the flag code of India? What is that flag code of India? That if you have private property, and for example you have a car, you have a house, you cannot hoist the flag on your private property. It was considered insult to the flag. It was considered the insult to the flag of the country. So he went to the Supreme Court and said, sir, listen, I want to hoist I love my country, I love my flag, and I want to express my feelings towards the flag of our country. And how I can express it? I want to express it by hoisting the flag of our country on the roof of my building. I want to express my feeling by hoisting the flag of the country in my car. I want to have a little flag of our country in my car. I want to have a badge near my heart. I want to wear the badge of the flag of the country near my heart, but I cannot do it because it is considered under the flag code. It is considered that it is the insult to the flag of the country. It is insult to the flag of the country to hoist it at the private properties. So to it, this Supreme Court said, flying the national flag is the symbol of expression and you can do it. So what does the Supreme Court said? That flying the, if you want to fly the national, if you want to fly the national flag, it is the symbol of expression and you can do it. So if you will look at now, why I am giving you the example, if you look at the expression, if you look at this at the words, it says to freedom of speech and expression. This does not contain it in words that you can hoist the flag, but it is interpreted from it, it is inferred from it that you can do it. So this is one of the classical case how judiciary has interpreted it. Then similarly, similarly it is one case. Then let's jump to the another case with respect to the association of democratic reformers. So let us see what does they say. you know let's discuss what does they wanted to know and how Supreme Court interpreted it for them. As I said, it is a very wide topic, it is a very broader topic. Association of democratic reformers, you would have heard about ADR. One day they decided they will go to the Supreme Court. They went to the Supreme Court. It is related to this ADR, little information about it. It is an NGO, basically mostly related to what? Related to electoral reformers. Electoral reformers. So what they decided that they should go to the Supreme Court. They approached the court and they asked the Supreme Court, sir, can I ask questions? Can I ask questions? So Supreme Court said, yes, you can ask questions, but what are the questions you are going to ask? And to whom you are going to ask the questions? Are you going to ask me the questions? Then there would be certain kind of restrictions to you. If you are, suppose you are going to ask me questions about the cases, it is fine. Then but there are certain restrictions. Can you ask me, you may ask me questions about the Indian polity. Right now we are discussing. That is fine. I would love to answer that. But can you ask me questions which are very much personal to me? No, you cannot ask those questions to me, and I am not supposed to answer those questions. Similarly, they went to the Supreme Court and said, sir, can we ask the questions? Supreme Court said, what kind of questions you want to ask and to whom you want to ask? They said that, sir, when there are elections in our country, at that time many candidates nominate their names for the elections. They nominate there are many candidates who nominate their names to contest the elections. We want to ask questions to those candidates. We want to ask questions to those candidates. And what are these questions? First, we want to ask them what is their educational qualification. What is their educational qualification? We want to ask them, even if they are not educated, but at least give us the opportunity to ask them, because we are going to vote them. We need to have this information about them, what kind of people they are, what is their criminal record, what is their education, how they are going to impact the country, how they are going to raise the standards of the country, raise the standards of the citizens of our country, how they are going to do that. For that, I need to make a very educated vote. I want to cast my vote very, very informative. When I will cast the vote, it should be based on the information. It should be based on the education. It should be based on the information which I have about the candidate. So the Supreme Court said, what questions you are going to ask? He said that first they said, what is the educational level of the candidate? Second, what are the assets they own? What are the assets they own? And what are their assets? What are the assets their spouses own? We want to know about that. And third, if there is any criminal case against them and how many criminal cases are against them. We want to know these questions. We want to know this much information from the candidate. Please allow us. So Supreme Court said, yes, there is no problem in it. You can ask them whatever you want to. If you want to ask these questions, go and ask them these questions. But you cannot ask them personal, silly questions about their relationships or that is something personal. If you want to ask these questions which are for the better interest of the country, then do ask them. So if you now coming back to the statement, if here see freedom of speech and expression, it does not define that you can ask questions. It does not talk about the right to information, but it is inferred from it. It is inferred by whom? It is inferred by the courts. So this is the very broader, it is the very broad statement. It is, even though it may look very small statement, but it has a very broader meaning. So with respect to this, what, you can ask the questions to them. Now again, ADR, as they are, their work is based on the electoral reforms. So they again approached Supreme Court. But this time the question was different. They approached the Supreme Court, and what was the question? It was about the electoral bonds. What was the question they asked? That they said that, sir, is it not our right to know who is funding any political party? Supreme Court, let's suppose, Supreme Court said, why do you want to know who is funding any political party? Then the ADR says, in a hypothetical way, it says that, sir, maybe tomorrow government will change, and we would need some developments, we would need to improve our infrastructure, and for that certain companies are favored. We need to know whether these were the companies who were giving them the money, who were funding the political parties. We want to know whether there is any scope of bias or scope of corruption. Is there any scope of corruption? For that, we need to know who is funding the political party. So the Supreme Court got satisfied. They said, yes, you don't, you if you want to know, you can know, because it is very much the argument which you are making here. It is a great argument, because you want to know whether there is any corruption. It is the very much under the scope of Article 19, right to information. Then they said, sir, what about the electoral bonds? Supreme Court said, what about electoral bonds? What is wrong with electoral bonds? What is the issue with electoral bonds? They said, sir, about electoral bonds, there is a specific issue. If you want to fund any political party, what you have to do? You have to go to SBI. You have to go to SBI. You will, you will buy electoral bonds from them, and you will give it to the political party, and political party will encash it in the SBI. It will encash in the SBI account. Then it will be funded to the political party. But about the electoral bonds, there is an issue. It is very much anonymous. There is no name of the person who is funding it. Neither there is a name of the political party, nor there is a name of the person who is funding it. It is just it is handed over to the political party, and they encash it in their accounts. So there is huge anonymity in it. So if there is anonymity in it, we are not knowing who is paying the political party. We don't have this information. If we don't have this information, how could we know that? What were the companies who were funding any political party? Suppose right now we have the BJP government. How would we know that who were the companies who were funding the BJP government? So in this, it was really serious matter. So government got also involved, and there were few arguments made by the government. What were the arguments made by the government? Government's arguments were, sir, until they were asking about the political candidates, it was fine, because it was about the candidates. They wanted to know, they want to cast their votes with their full potential of understanding of the society. They want to cast the vote. That was fine. But what do they get? What will they get by knowing about the political party? But the situation is different in our country. You don't vote the candidate, you vote the political party. And at the same time, when the political party is getting the funds, they know who has paid them. The person who is funding them, they know who they had paid. And when there are such projects, there can be the bias, there can be the corruption. So by taking this argument, the Supreme Court said that, well, the electoral bonds, it is unconstitutional, because there is a right known as right to information. It is very much fundamental right. It has the scope under Article 19, and you need to know who is funding that. Then you want to cast the vote. So this electoral bond is unconstitutional. So this is the issue with it. So this was the issue. This is how the whole concept of discussing these cases. What is the whole reason why we discussed the case of ADR, why we discussed the cases with respect to Naveen Jindal, why he approached? What was the reason for that? The reason for that is the statement in the Article 19 itself. As we can see here, all citizens shall have the right to freedom of speech and expression. It is not confined it has a broad understanding, it has a broad there is a broader spectrum, there is a broader understanding. And what is that understanding? It is inferred by whom? It is inferred by the government. It is, sorry, it is inferred by the judiciary will interfere, infer it for you, and they will say whether it comes under the scope of freedom of speech and expression or not, right to information. Similarly, you want to know, you want to hoist the flag, you want to do something, everything is not contained in it. You want to make a movie, it is not contained in it. But if you have, if you want to make a movie about anything, it is not, all this is not confined in it, but who will interpret it? It will be interpreted by judiciary. So that was the reason why we discussed these cases. So this freedom of speech and expression, it is not an absolute right. Now we have to understand that the freedom of speech and expression in itself, it is the Article 19, Clause 1A. It is not an absolute right. It is not an absolute right. There are certain restrictions imposed by the Constitution itself. Now let's try to discuss what are those restrictions one by one. Let's try to understand them. Then we will move to the next article, next clause of it. So let's try to discuss what are the various restrictions given under this article subclause. What are the restrictions to Article 19, Clause 1, subclause A? Here they are given under Article 19, Clause 2. What are the restrictions to it? Article 19, Clause 2. Restrictions, the state can impose restrictions for reasons such as sovereignty and integrity of the India. Second, security of the state, friendly relations with the foreign states, public order, decency or morality, contempt of court, defamation, and incitement of an offense. Now let's discuss them one by one, how they are the restrictions and how they are necessary, how they are the necessary restrictions of this article. Otherwise there could, there would be jingoism in our country if these restrictions were not there. Let's try to discuss them, let's try to understand them one by one here. Let me rub it first, then we will start with the restriction 1. So till now I hope you had understood Article 19, Clause 1, Clause A. Now what is the first restriction? It says sovereignty and integrity of India. The state can impose restriction for reasons such as, first, sovereignty and integrity of India. So what is this? Why there is a reason for that? You have the right, when we have the right of freedom and expression, when we have this right, when we have the right to freedom of speech and expression, what we can do in it? We can do whatever we want, but with restriction. We can do whatever we want. We can be the cartoonist, we can make movies, we can I can make a song, I can write a poem, I can do whatever I want to do, I can say whatever I want to say, but there are restrictions. The first restriction is sovereignty and integrity of India. How it will impact it? Suppose I am a cartoonist or I am a writer. Suppose I teach geography to you guys, and I am going to make a map of India, and I will not add the Kashmir in. I will not add Kashmir as the part of India. So what does it show? It impacts the sovereignty and integrity of India. So this I cannot do. I'm trying to make the map of India, and I'm not adding the Kashmir region in it. It definitely impacts the sovereignty and integrity of our country. It impacts the sovereignty of India, and we cannot do it. And this clause, this restriction, when it was introduced by the 16th Constitutional Amendment Act, during in the year 1963. It was China versus India. During that time, China versus India, a war was going on. So during this time, this Constitutional Amendment Act was introduced. So you cannot do it. You cannot make a map, because it will impact the sovereignty of the country. It will impact the integrity of the country. You cannot say that Kashmir is not part of the India. You cannot say that Punjab is not part of India. You cannot make map tomorrow that you will exclude Punjab and mark it as a Khalistan. You cannot do it. You cannot exclude Tamil Nadu. You cannot say that the North India is not part of India now. South India is not part of India. So it will impact the sovereignty and integrity of the India. It will impact the sovereign nature of our country. That is why there is a restriction. You can say whatever you want to say, but don't impact the sovereignty and integrity of India. Don't touch this phase. Don't touch the sovereignty and integrity of India. Say whatever you want. You want to criticize the government, criticize it. You want to criticize the policies, criticize it. You want to criticize the laws, criticize it. But don't say that India is not Jammu and Kashmir is not part of Kashmir of India. Don't say that Punjab is not part of the India. Don't make such maps. Don't give this understanding to the country, to the nation. So this is what this first restriction is about. And please know, when it was introduced through the 16th Constitutional Amendment Act 1963, when there was China, there was a tussle between China and India. So this is the first restriction. Very simple to understand, very easy for everybody. So with this, let's move to the second restriction. First, let me rub it. I don't want to waste your time in that, but it is the necessity right now. Let's see what is the second restriction which we had brought in, which the Constitution has given us. The second restriction is the security of the state. Second restriction, what is this? Second is the security of the state. Security of the state. So this is something which we have to discuss right now. Suppose you are in media. And there is a war. Recently there was a war. A kind of war between India and Pakistan. And you were on the border. You were working on the border. You were covering the war. How as if similar to 1999, when there was tussle between India and Pakistan. So similar to that, you want to cover this battle between India and Pakistan. And when you were covering it, you would be on the side of Indian border. Suppose it is Pakistan, it is Indian border. You are on this side, and you are covering this war. And what you are doing, you are covering it. You are giving the live representation of it. You are going live on the battlefield. You are showing where are our camps. You are showing how many battalions are there. You are you are telling the world that it was not your intention. You are telling the people that we are holding strong. We have this much army there. Our camps are so strong. We are using these weapons. We are using that. We are going to do that. We are going to attack them from this side or that side. So can you do it? No, you cannot do it. Why? Because it impacts the security of the state. If you will do that, when you are putting this on the media, when you are showing this to the world, Pakistan will also watch your media, and they will come to know about your strategies. They will come to know about your army, and they will engage in that way. So even though your intentions were very clear, but still you can't do it, because it will impact the security of the state. It will definitely impact the security of the country. So that's why this is one of the restriction. You can be the journalist. You want to do whatever you want. You want to take up any case. You want to discuss any case. Right now there is a murder case, Operation Honeymoon, which is going on presently. Honeymoon. You want to cover the case. You can do it. You want to know about the woman who was involved in it. You can do it. But you cannot go to Meghalaya and you cannot point out the pictures of the army camps there. You cannot highlight those on the you cannot highlight those on the live TV and show these are the places where we have the army camps. These are the places which are vulnerable to attacks. You cannot do that. It will impact the security of the state. You would have heard about Jyoti Verma. I guess it is her name, which is framed of what? Framed of which is framed that she is the spy of Pakistan. She used to work for the Pakistan. I did not follow the case, but this can be the scene for her. This can be the reason for her why she is under the jail, because Well, I don't know, right? Presently I don't know what where the case stands with respect to her. But what she did, she had when she was in the Pahalgam, she has collected the data. Maybe her intentions were clear or not, it is up to her, and the government will decide about her. But what she did, she gave the info, and the info she collected from the Pahalgam, or whether she was in Pakistan. So she, in this way, she impacted, what she impacted the security of the state. So she would be held responsible for that. So in this way, you can be any journalist, you can be any cartoonist, you can be anybody. But if you are impacting the security of state, this is a restriction. Do whatever you want, but don't impact the security of the state. So this is the second restriction for Article 19, clause A, clause 1, subclause A. What is the third restriction? It is about the state can impose restrictions for reasons such as friendly relations with the foreign state. What is this friendly relations with the foreign state? Let me rub it first, then we will discuss that. You know, as the Operation Sindur was going on presently, and suddenly both the countries agreed, Pakistan approached India that we should go for ceasefire, and that is better for the situation right now. And both the countries agreed. But we saw that how Donald Trump entered into the picture, and Donald Trump, his office, they announced the ceasefire. What they did, they announced the ceasefire. When they announced the ceasefire, if we look at the relation between India and USA right now, India and USA right now, we have very great relationship with USA, especially from 2017 onwards. Our relationship with the USA has been very great. They had favored us. We have nuclear deal with them. They had, we had huge business with them. But when this incident happened, what Trump announced it, and there were agitations in our country. There was, in a way, protests against country. And you would have heard that there is an MP, one of the MPs, she is very much notorious for her speeches. She is also a good actress. I really appreciate her acting. Kangna Ranaut. She said something about Donald Trump. Once she tweeted something about Donald Trump, in which she, in a way, insulted Donald Trump. But after some time, she deleted the tweet. Once she deleted the tweet, and then she gave the clarification for that. It was under the emotions, I could not handle that, and all that. So what does this mean? You have a friendly relationship with USA. We have a friendly relationship with USA, and the restriction to our freedom of speech is that you cannot say anything bad about the country with which we have the friendly relationship with foreign state. You cannot say anything bad about the USA, because you cannot give them the optics that the people in our country does not like you. We cannot give that optics, and that was the exact reason why the ma'am Kangna Ranaut, who is a very good actress, I appreciate her acting, but her speech is very different. She was made to clear that tweet. That is the restriction. That is Article 19, clause 2. It gives this restriction to her. It puts this restriction on her, that say whatever you want to say. You want to criticize the Pakistan, abuse them, insult them, say whatever you want to say. You want to criticize Bangladesh, be little bit limited in that, because we want Bangladesh. You want to criticize Donald Trump or USA, you cannot criticize it. Be very much respectful in that. If you have some disagreement with them, be respectful with them, because we have friendly relationship with them. You want to criticize Russia, be very much respectful towards them, because we cannot tolerate, we cannot handle their if they go against us. You want to criticize Iran, be very much respectful them, because we have a great relationship with them. So this restriction, it is provided by whom? It is provided by Article 19, clause 2, to the first to the freedom of speech and expression. Then what is the fourth restriction? It is the public order. So what is this public order? Let's try to understand that. Let me rub it first. Initially this public order, this fourth restriction, it was not part of the constitution, but it was introduced. Public order, it was introduced by the Constitutional Amendment Act, first Constitutional Amendment Act in 1951. And what is the story behind it? Let's dig a little deep into the story. There was a magazine, Bombay Mirror, namely Bombay Mirror, and it was written by the leftist political association who have the it was written by whom? Though those who have the leftist ideologies, extreme leftist extreme ideologies, who believe in socialist. So what government of Madras did? Government of Madras decided to stop the circulation of this magazine, which is named as the Bombay Mirror magazine, named as Bombay Mirror. It was stopped. It was stopped by Madras government. Madras government decided to stop it. So there was a person named Ramesh Thapar. He approached Ramesh Thapar. He approached Supreme Court that I want to read this magazine. I want to read this magazine, but right now the Madras government has stopped this circulation. The Supreme Court asked Madras government, why you are doing this? Madras government said, sir, we are not stopping them from from editing these magazines. We had not stopped them to edit these magazines. What we had stopped them to circulate it. Supreme Court said, why you had stopped them to circulate these magazines? The Madras government highlighted that there is an issue. What is the issue? The public order. They are writing something which will affect the public order of the state. The Supreme Court said, we have Article 19, and in Article 19 we have right to freedom of speech and expression, and we have restrictions, and this restriction, public order, it was not present that time. The Supreme Court highlighted that is public order any reasonable restriction to it? There was no such order. There was no reasonable restriction named public order in the initial constitution. So the Madras government said, sir, no, there is no such restriction. So the Supreme Court said that what you had done is unconstitutional. What Madras government has done with respect to magazine, with respect to Bombay Mirror magazine, they had stopped its circulation. When you are stopping its circulation, you are holding people not to read it because they are not able to get it. So this is you are impacting or you are violating the right to freedom of speech and expression, and it is very much unconstitutional. So what happened after that? The Parliament came in. They decided to amend the constitution, and by the first Constitutional Amendment Act, it was introduced that public order would be the reasonable restriction to it, would be the one of the reasonable restriction to it, and it was added into it. So this public order, if you will analyze the public order, it is something which we can say it is a curse on the creative people. Public order, it is a curse on the creative people. If you want to write anything, suppose you wanted to make anything, you wanted to make a movie, you wanted to highlight the issue of India during the independence, you wanted to highlight various issues. This public order, it became a curse on the curse on the creators. You would want to say anything. Suppose you would want to say anything, you would want to write anything, you would want to make anything, you would want to do whatever you want to do, but this restriction would always be there. This restriction would always be there, and it will impact your creativity. It will adversely affect the creative pursuit of yours. There may be valid reason for that. Why there is this public order? There may be valid reason for that, but it is still there. It is there, and this is one of the restriction to the Article 19, Clause 1, Clause A. Now, what is the another restriction? Another restriction is decency or morality. Now, let's discuss the fifth restriction. I guess it is, yeah, fifth, decency and morality. So, what is this decency and morality? Anything may be decent to you, may not be decent to me. Anything moral to you may not be moral to me. So we cannot say that this decency and morality, it is something that that is defined by the social norms. It may change. If we will look into the Hindi cinema, earlier, if they have to show the affection between two lovers, they would put some curtain between them, or they will show that the lights are off. It was the way in which they would have shown that there is love affection between the couple. But now If that time they would have shown the if they would have shown the erotic scenes which we can see in present movies, if that time, if in 1960s and 70s they would have shown these erotic scenes, it would have not sounded good on the people, and it would have been called that it is immoral, it is indecent, it is not decent. So there would have been protests against the movie, and it would have been demanded that this part should have been removed from the movies. But the time has changed. Right now, any director, no director will decide, will show that by switching off the lights that they are making the love. Erotic scenes are very much normal, and they are accepted by the society right now. So what my point is, what is moral, what is decency may not be moral to anybody, may not be decent to anybody. So what it shows that the social norms of morality and decency is not defined here. It is not talking about the social norms of morality and decency. It is what constitutional morality means. We believe in liberty. We believe in liberty. We believe in freedom of expression. We believe in we believe in expression of thoughts. We believe in these norms. This is morality to us. This is the constitutional morality of equality, liberty and dignity. These are the constitutional moralities, and these are to be respected. These moralities are to be respected. Suppose tomorrow a couple will come to the court, and they are of the same sex. And they are in an intimate relationship between each other. And what does the social morality say? Social morality says that it can't happen, because socially we are not accepting it in our country right now. If we look at the Western countries, way before, if we will go back to 1 or 2 centuries, it was not accepted there. If we will go back 50 to 60 decades, it was not accepted in the Western societies as well. But right now, gay marriages are very much legal there. These homosexuality, it is very much legal there, and it is cherished there. Similarly, the social, we are not believing, when we talk about the decency and morality, it is not the social morality. If we look at the social morality, it should not be allowed. But what does the Constitution say? Constitution says we believe in liberty, equality and dignity, and they have the right to love each other. And homosexuality, it was made what? It was decriminalized. Homosexuality, it was earlier criminalized, now it was decriminalized. So this is the morality. It may be different. Similarly, you want to make a movie. For that, whether you want to see whether it is obscene, the concept of obscenity, that it is related to decency, it may also change. As I told you earlier, when they have to show the affection, they would switch off the lights. Now they show the erotic scenes in the movie, but still they have some limits. If we compare it with the Hollywood, you would have seen if you would compare it with Hollywood, you would have seen various movies there. For example, I remember 50 Shades of Grey. Then we have different movies like another movie, Mrs. Chatterley's, I guess, Lover. Mrs. Chatterley's Lover, a very erotic movie. We have the Wolf of Wall Street, very erotic movie. This norm, it is very much accepted in the West, but in our country, with respect to Hindi cinema, we had not reached to this level of indecency, this level of obscenity. We had not reached to this. So that is why, if such movies would be shown, maybe there would be some challenges to such movies, but maybe time will come when our society will also accept that. Right now, pornography is not accepted because it is the social norm. Maybe after a few years, like in Western countries, similarly India will also accept the pornography. So this obscenity, this decency, it can be restricted. Your fundamental rights can be restricted, but it can be the reasonable restriction. Similarly, the case I want to highlight here was with respect to the Mrs. Chatterley's Lover. Mrs. Chatterley's Lover, it is a movie also made over it, and that is available on the Netflix. This movie is available on the Netflix. So with respect to that, there was a novel, it was published. This novel was published, and there was put ban on this novel. Reason was that it is highly obscene. It is highly obscene, and this ban, for that you need to know about the Hicklin test. This Hicklin test, it will show, it will give this status to the movie whether it is obscene or not. And this Lady Chatterley's lover, this book, it was banned in India because it was very much obscene at that time. This Lady Chatterley's novel, it is written by W.H. Lawrence. So similarly, there can be various other reasons. So this is about the public order, this is about the decency and morality. It can also be the reason for the restriction of the fundamental rights. Right now, you cannot make a pornographic video in our country. You know, we have the freedom of speech and expression, but you cannot make the pornographic video because this decency and morality is one of the restriction on your fundamental right. So with this, I hope you had understood it also. You know, you may believe that the homosexuality should be banned, but we believe in the morality of the constitution. So there are different discussions for certain points. You know, we may be very much socially involved, for example pornography, but for homosexuality the courts had agreed that they had decriminalized homosexuality, but yet they had not established that, they had not legalized the marriage of the homosexual marriages. They had not legalized it yet. It is continuously changing. Right now, if we look at the mix of our, we are in the mix of social and constitutional morality. Sometimes the constitutional morality prevails, sometimes constitutional morality is given the same meaning as the social morality. And how we can differentiate it? By different cases. About homosexuality, about legalizing homosexuality, we said that very much correct, nothing wrong with it. But when we have to legalize their marriage, we said no, it is not, it is against the definition of the marriage. Similarly, you know, about the pornography, banned in our country, you know, but what does the constitutional morality say? That you have the liberty, equality and dignity. So these things are ever evolving, but the point about this decency or morality, it is that it can be the reason of restriction of your fundamental right. Now what is the sixth reason of restriction? It is the contempt of the court. Now let's discuss the contempt of the court, what this is. What this is, let's try to discuss it, let's try to understand it, and then we will move to the another slide. Till now, I hope you had understood Article 19, Clause 1, Clause A, the freedom of speech and expression. And right now we are discussing, we first discussed the scope of Article 19, Clause 1, Clause A, Subclause A. We discussed the scope. Now what we are discussing? We are discussing the restrictions, and one of the restriction to it is contempt of court. You know, contempt of court. If you look at the contempt of the court, it in itself is not mentioned anywhere. It is not mentioned, sorry, not defined anywhere in the constitution. So how we know that anything is contempt of court? For that we have to look at the Contempt of Court Act 1971. We have to look at Contempt of Court Act 1971. So what does it say? It defines the contempt of court in two ways. What are these two ways? One is civil contempt. Civil contempt. What is the civil contempt? For example, you have some case in the court, and courts will give you the another date, that date you have to visit the court again, and you are supposed to be there. But what you did, maybe intentionally or unintentionally, you did not visited the court. This is called civil contempt. It is not that much seriously taken by the courts, but still you can get punished for that. You may end up in jail for 1 day. And the another is criminal contempt, defined by the Contempt of Court Act 1971. What is this? You are secondalizing the judges, you are secondalizing the authority of the court, you know, you are obstructing the justice. Then it would be the contempt of the court. You are lowering the dignity of the court. Suppose what courts decided, gave any judgment. In that judgment, they have to do the construction of any building, suppose, and you did not, it is against your wish, you did not wanted that building should be constructed. So what you will do? You will go there and you will try to stop them. You will try to stop them in building the building. So this would be the criminal contempt. Second, you will scandalize the judges. For example, you would say that they did not favor me because they belong to particular religion, they belong to particular community. they had some relationship with the government, you are scandalizing them. So what it will lead to, it will, if you would highlight these points, it will lead to the trust which the people have in the courts, the trust which the people have in the courts. It will impact the trust, that judicial trust. That's why it is the criminal, it comes under the criminal contempt. So who will file the case for the criminal contempt? Now the question comes, who will file for that? First, a court may take the action as suo motu. If they will find out, if for example you will say anything wrong, you will do anything wrong, courts will know that and they will file the case suo motu. Second, attorney general or solicitor general, they will approach the court. Third, any third person, but they have to take the information, they have to take the they have to take the they have to ask permission, they have to take the permission from the either from the attorney general or the solicitor general. These three people can approach the court and they can approach for the contempt of the court. What is this contempt of the court? It can be defined into two. One is civil contempt, by not following the orders simply, and the other is criminal contempt. You are secondalizing the authority of the court, you are obstructing the justice, you are lowering the dignity of the court, or you are stopping, as I highlighted, the construction, you are stopping the construction here. So is there any case in which the contempt of court has been done? 100% various cases. Can judges be held for the contempt of court? Yes, 100%. And the example for that is the Mr. Justice Khurana. Justice Khurana, he has been held for the contempt of court. What he had done, Justice Khurana, he wrote the letter to PM and highlighted that there are some certain judges who are taking the bribes, who are involved in corruption. Certain judges are involved in corruption, and while writing this this letter, what information does it give to the people? It gave that these judges are very much corrupt and they cannot give justice to us. So he was booked under the contempt of court, and 6 months jail was given to him. He is the only judge who was booked under this. 6 months jail was given to him. So this is about the contempt of court. Now suppose you want to, now there is a question, there is a judgment, for example the judgment on reorganization of Jammu and Kashmir, and you find out that in this judgment there were certain points which were ignored. For example, can this by revoking the status of statehood, by giving it making it the union territory, we are breaking the state, we are breaking the federal structure. Is it against the federal structure? This was the point raised there. And what is the court said? Court said that let's leave it here, they are going to give the statehood back. If it is done again, we will take it into the consideration. We can, what we can do, we can criticize the judgment here. We can say that this judgment was not that good, or we can say that the judgment was totally bad. This is very much fine. This may not come under the contempt. So this is very much very much defined that if you are criticizing the judgment, that is fine. You can criticize the judgment, you can say the judgment was bad, judgment was not good, but you cannot criticize the office that the judges are corrupt. You cannot scandalize it. You cannot say that the judgment was not in my favor because I was Muslim, because I was Hindu. You cannot say that because I belong to any particular caste. You cannot say all this stuff, because you cannot scandalize it. You cannot give this impression to the people that there is a biasness in our judgment, in our judiciary. You can say that this case study was not done properly. You can say that there was no I guess they lacked the proper understanding of this issue. You can say all these issues, all these things, but you cannot scandalize the judiciary. And second thing, suppose you are saying anything. Suppose the judiciary gave the judgment about the construction of building, and you said that I will not allow it. This construction should happen. I will not allow it. I will die for it, and I ask people to not allow it, to protest there and stop this construction. But on the construction day, nobody came. Neither you were there, nobody was there, and you were involved in your life. So you can't be held for the contempt because you just said it. You did not stop it. So these were some things which were highlighted with respect to the contempt of court. Similarly, if you want to criticize the judgments, you can criticize. We have some examples for you in which the judiciary was criticized. For example, the case, the Mahinder Singh case, in which he had raped his own daughter. He was in the jail, and it was asked that he should be hanged. The two judges who were hearing this case, they said that no, it is not the rarest of rare case. We cannot hang him, because to hang the case should be rarest of rare. And he was given the life imprisonment. He was given the life imprisonment. After some time, he went out on the parole, and what he did, he committed the murder of his daughter, of the same daughter whom he had raped, and his mother. And the case again came to the judges. What they said, that no, it is not rarest of rare case, so no hanging to him. After 2 weeks, what happened? There was another case, and it was heard by one of the two judges. And what was the case? A minor son, a 7-year-old kid, was brutally killed. And what was the judgment? That it is the rarest of rare case. He was the only sole he might be the, as he was the sole male child of the family, he would have been the bread earner for them. So it is the rarest of rare case, and the person who murdered him should be hanged. So this judgment, it was highly criticized. According to some, it showed the patriotic nature of our society. It was shown by this judge also, by highlighting that he is the only male child. It showed the patriotic nature of the patriarchal nature of the society. But at the same time, the way they let the person Mohinder Singh let go because he murdered his child and wife. Their judgment was different, so they were criticized for that. You cannot, the people who criticized them, there was actually there was a criticism over it. There was huge criticism over it. So they were held for, they went to the court. They were, there was case against them that it is under the, it comes under the, under what? It comes under the contempt of court. The judiciary said that no, it is not the contempt of court. It is just a criticism. Criticism of the judgment can't come under the contempt of court. Similarly, if we will see our previous CJI, Mr. D.Y. Chandrachud, he was also criticized for his observation on the Places of Worship Act. On the Places of Worship Act, his observation on the Places of Worship Act. Under this act, on the Places of Worship Act, under this act, 1991, whatever was the status of any monument on the day of 15th August 1947, it would remain same. If its religious characteristic was masjid, it will remain masjid. If it has the mandir characteristic, it will remain the mandir, or whatever its characteristic was, it would remain the same. So with respect to this, what happened? The Gayan Bapi Mosque came in, Gayan Bapi Mosque, and case was filed. The case was accepted by the judiciary. The case they approached the Supreme Court. Sir, it is the violation of this article. It is the violation of the of this act, Place of Worship Act. The K.S. D.V. Chandrachud said that no, it is not in violation. This act says that the nature of the character of the religious place can't be changed. We are not changing the characteristic of the religious place. We are not prohibiting. We are not there is conversion of a place of. There is no conversion of the place of the worship. But people want to know what was the status of the Gayan Vapi Masjid. Was it really the birthplace of of this of the Hindu deity? Was it really the birthplace of that? People want to know. Let them know. So on this reason, he was criticized. This Place of Worship Act, it is under the domain right now. There is a case against it, whether it is constitutional or not. That we will discuss once the judiciary will give its final verdict. But here, the point why I highlighted this is because the CJI was also what? He was also, he was also criticized, and it does not come under the contempt of court. So this was the another great reason, which this is also one of the restriction to the right to freedom of speech, which is contempt of court. Now, what is the seventh restriction to the freedom of speech? Now let us discuss that. Let us see what is the seventh restriction. The seventh restriction is the defamation. Let's try to understand what this defamation is. Let's try to discuss that. Defamation, what it is. Defamation, It is the restriction to the freedom of speech. You cannot you can say whatever you want. You can say whatever you want, but you cannot insult me. It would come under defamation. And you cannot insult us. You cannot defame my reputation. I have a reputation. I have a right to reputation. You cannot defame me. You cannot falsely accuse me of anything. Right to reputation. You would had recently heard about Kunal Kamra. His he gave his show in Navi Mumbai. He in which he insulted the CM, the deputy CM of Maharashtra. So he was booked under the defamation. Was that case right? That is something different. But what he did, his speech impacted the reputation of the Mr. Deputy CM of that state. So defamation, you cannot say anything which will impact the reputation of any person, which will impact the reputation of any person. So with respect to defamation, there are two types of defamation. What are those defamation? First one is it can be civil offense. Civil offense, he insulted Eknath Shinde Saab. He made certain remarks with respect to him, with respect to his looks. So what Eknath Shinde Saab can do, he can file a case of defamation, and he will charge certain amount of money for this. He will ask for the compensation, and this compensation can be anything. It can be 1 crore, whatever he would want to. This is the civil defamation. And the another one is the criminal defamation. This we had borrowed from the Britain. This is basically the colonial legacy which we follow right now. In the Britain government, they had ended this criminal defamation in Britain. Now there is only civil defamation, but we still have this criminal defamation. What is this? Under this criminal defamation, you can be given jail term of 2 years or more. And in defamation, it is this. In the criminal defamation, it is the state which will which will be the other party. For example, Kunal Kamra said anything wrong about the Eknath Shinde, and he will go to the court. He will say that he defamed me, and the state will have to come in and restore this right to him. So the third party which would be involved, it would be the state. So this is the defamation. You cannot defame anybody. Similarly, it is very much under this defamation with respect to criminal defamation. It is under huge scrutiny. People are it is under always under discussion whether it should be there or not. So similarly, if you would have heard about Rahul Gandhi, when during elections he said that all the Modis, all the people who had the surname of Modi are often thief. He said that, and for that a criminal defamation case was put against him, and he was told to go to jail for 2 years. Once, if he would have gone to jail for 2 years, he would have not been allowed to contest the election. But what he did, he went to Supreme Court and he filed an appeal in the Supreme Court, and the case is still there. When Supreme Court will take the case, then it will be decided. So in nutshell, what the point here is, the another reason that you can say whatever you want, but you cannot insult anybody. Everybody has their reputation. I have my reputation. You can insult the way I teach. You can say that the Salvation IS does not teach well. You can say that there is some issue with us. You can say that, but you cannot abuse us. You cannot defame us. You cannot defame our reputation. You cannot say that we are taking certain amount of money from the YouTube. We are taking certain amount of money from you, then only we are delivering these lectures. We are taking certain amount money from the government. You cannot defame our reputation. So this is the limitation to the article 19(1), 19 clause 1 subclause A, which is the freedom of speech and expression. And the last restriction to it is the incitement to an offense. So let's discuss what this incitement to an offense is. Let's try to understand that. suppose, you know, you can say whatever you want as per article. You can say whatever you want. You want to protest, protest. You want form an organization, form an organization. But you cannot tell people, you cannot tell people to go and kill somebody. You cannot tell people to come at certain place and start pelting the stones, or and start pelting the stones. You cannot do that. You cannot incite. You cannot go for the incitement of what? Incitement of offenses. You cannot let people go for the. You cannot let people to go for the offenses, to make these offenses. You know, you cannot make you cannot the state has imposed restriction on incitement of an offense. You cannot say that. You cannot promote the hate speech. You cannot promote the hate speech. You cannot say you want to criticize the government. You cannot criticize the Hindu religion. You want to criticize certain people. You want to criticize the terrorists. You want to abuse them. You want to kill them. You cannot say that kill all Muslims. So this would come. It would incite and what it will incite an offense. It will incite an offense in the society. So you cannot separate the hate in the society. This is what this restriction is about. You cannot say that kill them all. You cannot say that desh ke gaddaron ko goli maro, whatever is further. You cannot say all this. This comes under the incitement to an offense. You cannot push people towards the offense. Go and vandalize the shop. Go and do the mob lynching. This is the, you can organize the protest, but you cannot incite them to do any offense. So this is the final restriction to it. This is the final restriction to it. So with this, I hope Article 19(1)(a) is clear and its restrictions are very much clear. So till now, if you have any question, please do ask, but you cannot ask directly right now because it is not going live. If you have any question, do write in the comments. We will definitely come to the rescue. We will try to clear that confusion if you have any. Now after that, there are certain few points which we need to highlight, especially with respect to the Sedition Act, which was in the IPC. Let's try to discuss that Sedition Act. Then we will complete our today's discussion, and tomorrow we will discuss the right to freedom of speech and expression, right to freedom. In this we will discuss the Article 19, subclause B, C, D, E, F, and G. We will discuss these tomorrow. And here, the last topic of today is Sedition Act. Basically, it was in the IPC. And about IPC, if you know that it was basically introduced in 1860, but the sedition was later added it in 1870. In the sedition, what if you are writing anything, or you want to speak anything against the government, or you are writing against the government, you are bringing, in a way, you are writing that much that you are bringing hatred towards the government. You would be held under sedition, and what would be the punishment? It would be life imprisonment, imprisonment to jail. Either it would be life imprisonment or fine, or 3 years, or fine only, or imprisonment only. So it has the harsh penalties associated with it. So it was introduced in 1870 earlier. And who was the first person who was booked under sedition? It was Bal Gangadhar Tilak. Bal Gangadhar Tilak was booked under sedition because he had wrote a poem about in which he celebrated the killing of Afzal Khan by Shivaji. And it was a time when there was a Pune plague, and it was supposed that during Pune plague, the British officials, they had highly discriminated the people in Pune. So in response to that, one of the official was killed. So it was during that time he has highlighted this. He gave us he wrote a poem, and he was sent to the court. Court said him do you plead guilty? He said, no, sir, I don't plead guilty. I had not written anything against the government. How I can be booked under sedition? Then the court said that even if you had not written anything about the disaffection in the with respect to the government, but there is no affection for you towards the government, and he was booked for 6 years. For 6 years. Who was the second person? Majorly, it was Mahatma Gandhi. Mahatma Gandhi, after the Chora Chori incident, and he was booked under the sedition, and it was asked him, do you plead guilty? He said, yes, I plead guilty, and it is my moral duty to promote disaffection towards your government, in a nutshell. So these were the pre-independent cases with respect to sedition. After the independence, let us discuss those cases, then we will complete our today's discussion. After independence, there was a case, called Kedarnath Singh versus Kedarnath Singh case 1990, 1962, sorry. And in this, it in a way defined, it upheld. There was a question about the IPC, whether it should be upheld, whether IPC section 124, section 124A, whether it should be upheld or not. But it was upheld by the courts, by the judiciary. It was upheld. It was said that it is constitutional. But one thing, it was made very much clear that you cannot book a person solely on the speech. For example, if anybody is saying against the state, it does not mean that he should be booked against in the sedition, in the sedition case, until his actions are proven, until his actions lead to the incitement of the hatred towards the state. For example, you are saying, you are making slogans, there are slogans like Kashmir banega Pakistan, or something like, or jang rahegi Kashmir ki azadi tak. These slogans, for these slogans can't impact the republic of our country. It can't impact our sovereignty. Just these mere slogans cannot impact the sovereignty of the country. These slogans can do nothing unless it turns into the hatred, and there is disaffection for the state, and there are acts of violence. And once if these slogans lead to acts of violence, then only the person can be held under the sedition case. So this was made very much clear under the Kedarnath Singh case, but unfortunately there were many people after that who were held under the sedition case. For example, Balwant Singh versus the state of Punjab, similarly Shreya Singhal case, and Vinod Daha case. And also one thing about it was, there was very least convention rate in under such cases. So what was the result? The people will be held for years, and finally the courts will say that you were not guilty. So there was least convention, and finally the Supreme Court came in and they stopped. Supreme Court said that no person should be held under sedition. After that, we saw that how the IPC was revoked, and it was replaced by the Bharatiya Nyaya Sanhita, BNS. It was replaced by BNS in 2023, and there is no direct connection to the sedition. But we have a similar section there, which is section 152, in which earlier in the IPC it was against the government. Now section 152 says, whoso purposely encourages separatist activities. Suppose now it is against the nation. If you encourage separatist activities, you encourage those ideas which will impact the sovereignty of the country, then you would be held under this. You will be held under the this section of 150. Article 152, and the punishment would be almost same as what used to be in IPC. So this is about the sedition. Earlier it was decided, when the constitution was in making, it was decided that sedition should be also one of the restriction of Article 19(1)(a), but it was highly debated, and this idea was rejected. So this is all about the Article 19(1)(a), and these are its restrictions. I hope you had understood everything till now. Now with this, Let's solve some prelims based model questions which could be relevant for you. You know, last time in yesterday's class we did not discuss questions related to you know article 17 and 18. In today's class we will discuss them. Here the question says, which of the following statements is are correct regarding Article 17 of Indian Constitution? First, it abolishes untouchability and forbids its practice in any form. Correct. Second, the term untouchability has been precisely defined in the Constitution. No, it is not precisely defined. Third, the enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with the law. Correct. So, with respect to this question, the correct statements are statement C, 1 and 3 only. Now, another article, it is related, this question is related to Article 18. The question says, which of the following statements about Article 18 of the Indian Constitution is are correct? First, it says it abolishes all titles, whether military or academic. No, it abolishes all titles, but it retains the military and academic titles. So, first statement is incorrect. Second statement, it prohibits the state from conferring any title on its citizen. Correct. Third, it allows Indian citizens to accept titles from foreign states with the president's consent. No, it is not titles, but it is awards. You can accept the awards from the foreign state, but by the president's consent. About titles, you can never accept it. We know the Sunil Gavaskar case. Sunil Gavaskar case. Then the fourth, it allows citizens to retain titles conferred before the commencement of the Constitution. No, not at all. So this is also incorrect. Then we have question related to Article 19, yet we had not completed it. So we will discuss it once we will complete the article. So till now, I guess everything is very much clear. You know, we had discussed Article 19. We had discussed Article 19(1) Clause A. We had discussed right to freedom of speech and expression, and we had discussed its reasonable restrictions. So till now, I suppose everything is very much clear. If there is any confusion, do write in the comments. We are here to help you, and we would be very much happy to help you. And please do subscribe the channel.